Hey everyone, we're here today discussing what was a pretty interesting ruling by the ITAT Hyderabad the last week, and it concerns a case against Invesco, where the ITAT actually set aside Invesco, claiming their depreciation on goodwill and could have implications for those deal makers in the M&A space who might have similar arrangements. I have Samaahith here with me who'd be giving us a bit of background on the case and setting out why you, as someone in the M&A space, may be concerned about what happened here. Hey Samaahith, do you want to start us off with a bit of background?
Hi Hrishikesh, thank you for having me over. So I think before we get right into the case, I think it'll make sense to set some context on the whole issue of depreciation and goodwill, right? So up until 2012, the position of law was not clear. There were rulings on both sides, ones which allowed goodwill to be depreciated, and two where depreciation of goodwill is not allowed. Now, all of this was put to rest when the Supreme Court in 2012 came out and said, look, goodwill is a depreciable asset. This is what the law is, and this is how we interpret it. And that was the law of the land. This was the position up until 2021 when the government came out and said, look, we know the Supreme Court ruling. They've said that it's a depreciable asset. We don't agree. We feel that there are times when the value doesn't depreciate, or at least in some cases even appreciates. So the government felt that it was unfair for taxpayers to be claiming depreciation on goodwill and made legislative amendments to that effect. So the position right now is that post 2021, goodwill is no longer a depreciable asset.
Got it. So 2012 to 2021, goodwill is a depreciable asset. It isn't after 2021.
Correct.
But wasn't this case in that period when you could depreciate goodwill? So why did the ITAT have an issue here?
Yes, that's right. So to understand the ITAT's issue with that, I think we'll need to dive into the facts right now. So this was an internal group restructuring for a couple of subsidiaries of Invesco Limited, the asset manager. Now, what happened here was one entity, let's call it Invesco India, acquired shares of another subsidiary called Invesco Hyderabad from a Mauritius-based entity belonging to the same group. Okay. Now, this acquisition of shares happened at a valuation of about 244 crores, and they relied on a discounted cash flow valuation for this. Shortly after the acquisition was completed, there was a scheme of arrangement or a scheme of merger filed before the NCLT, where Invesco Hyderabad, the subsidiary, was merged into Invesco India. Okay. Now, this happened at a valuation, or Invesco Hyderabad, for the purposes of this merger, was valued at about 102 crores.
Okay, so just after the initial.
Yes.
Okay.
Right after.
I think one number probably stands out here. Where did that 140 crore or so go?
Good question. So what happened was Invesco India said, look, this is goodwill that was generated as part of the merger because we've absorbed that entity into us, into our fold. And the balance, so 102 was recorded as the assets that were acquired, and the balance 142 crores is recorded as goodwill on Invesco India's books. And it's on this goodwill that they tried claiming depreciation.
Okay, got it. So, I mean, but if the law did permit it, where did the issue arise? Why did the ITAT set aside this claim of depreciation?
Fair question. So, in ITAT's view and the tax department's view, they felt that this whole transaction structure was designed to artificially create that goodwill, that there was no goodwill that existed with the Invesco Hyderabad entity. It was all one big engineered transaction, so to say, to create the goodwill, claim depreciation on it, and reduce the taxable income in India.
Oh, okay. And did they have some sort of basis upon which they were basing this on?
Yeah, so a couple of facts that are relevant to how the ITAT reached their conclusion. Now, the first was, remember the two numbers that we talked about, 244
Yes.
crores and 102 crores?
Yes.
Now, these were arrived at basis two different valuation methodologies. But the issue here was they were closely dated. So one was dated 31st of March, or one was as of 31st March 2016. The other was of 1st April 2016. Okay. The ITAT questioned how one entity can have two vastly different values very close to each other. They said that didn't make sense at all. The second issue was they questioned the appropriateness of using the discounted cash flow method to value a subsidiary which ceases to exist as a subsidiary, because the appointed date for the merger was April 1, 2016. Okay, so that's when
Yeah.
the entity ceases to exist and it would be folded into Invesco India. So they came out and said, look, the entity doesn't exist from 2016, but how are you predicting cash flows for an entity for 2017, 18, 19, 20, 21? That was point number two. And the final point, I think, was also how they looked at the Mauritius entity there. So, to recap, Invesco India acquired shares of Invesco Hyderabad from a Mauritius based entity.
Yeah.
Now, this was for this transaction happened prior to 2017. So under the India Mauritius UTAA, these transactions are grandfathered. Okay, so the ITAT also looked at this and said, look, you've designed this whole thing has been designed to upstream cash to your parent entity, move cash out of India to your parent entity, and also in the process create an artificial goodwill, claim depreciation on it, and reduce your taxable income.
Got it. So a couple of factors, having that Mauritius link there, having two different valuations, and maybe you could have even argued that they could have just achieved this by a simple merger.
That's correct. That's correct. So I think anyone looking at the fact set would realize that, look, why did you have to make it a two-step transaction? You could have simply merged, because it's a
Yeah.
group entity, right? They're all group entities. You could have simply folded the two entities into each other, one scheme of arrangement, one valuation report, done away with.
So, I mean, do you think if I'm someone in the M&A space, if I'm someone who's restructured my business operations recently, and I've also maybe been depreciating my goodwill, do you think I should be concerned that the IT department is going to send me a notice one of these days?
Yeah. So the thing here is that if you've been depreciating now recently, you're
Since
likely
the
to
2021. I
correct.
mean.
So the 2021 amendments have clarified that goodwill is not a depreciable asset anymore. So if you've been claiming depreciation on goodwill as recent as now, you're likely to get or your case is going to get picked up for scrutiny. But otherwise, between 2012 and 2021, if you're indulged in a genuine amalgamation or a merger without the jugglery that we've seen here, I think you should be good.
Okay, so this is probably like a very, very specific
Correct. This
one-off.
correct. A very
Okay.
peculiar set of facts that I think ultimately led to ITAT reaching the conclusion that it did.
Okay, but just out of curiosity, how does the ITAT have the powers to pick this up? Because I mean, wouldn't they have been able to look at this whole scheme when it probably went before the NCLT?
You're right. So under Indian company law, whenever a scheme of arrangement is presented before a tribunal, before the National Company Law Tribunal, notice is given to various regulators, including the Income Tax Department. So they have, at that level, the opportunity to raise objections. Now, in this case, basis the orders that we've seen, they did not, right? This was also argued by the taxpayer in this case. But the tribunal said, look, that's fine. The tax department did not raise objections back then, but they're raising it now, and there are sufficient precedents that allow them to do it. So on that count, I think may not be the strongest argument to make.
Yeah, I guess the never fight the tax department, I
Yeah,
guess. But okay, thank you so much. I think that was a pretty helpful overview of this case.
Great, thank you.